So I'm delighted to be joined all the way from Sydney by Wotton Kearney partner and head of class actions, Amanda Beattie. Amanda was due to be joining me at last November's Global Class Action Symposium, but I'm afraid illness got the better of her. So better late than never. Here she is. Welcome, Amanda.
So much.
Right. So let's just dive in. You lead the class actions practice at Wotton Kearney. It's a very, very fast evolving market, the class actions market in Australia, as it is in most other territories. How would you say that the market's evolved over, say, the past 5 years, particularly on the defence side?
Question actually, because our class actions landscape was very heavily dominated for a long time by shareholder class actions.
Yeah.
And whilst we still have a number of those, there were quite a few judgments. As you know, often these things don't go to final judgment, but we had quite a few shareholder class actions go to final judgment. And they were unsuccessful for the plaintiffs in all instances. Some of them are going through an appeal phase now, but we saw them sort of taper off as a result. At the same time, consumer class actions were already tending to take over. We've seen those really build up. But one of the real trends we've seen lately is employment class actions. So
that's interesting.
Yeah, underpayments, failure to give benefits, that sort of thing. We've seen, I think last year was a bit of an anomaly in that there was over 20 filed. A lot of them were relating to the same particular issue, but we've seen a lot of those in recent years. So it's evolving from what used to be quite a sort of big end of town, financially dominated dynamic to involving smaller entities now than it has in the past.
Cool. Now, I know a lot of your focus is on product liability, and picking up from what you just said, I'm guessing the gap between derivative or shareholder actions is closing. And what are the main trends you're seeing right now? I'm particularly interested not just in the types of claim, but claimant strategies, funding models, the general sort of holistic approach to how class action, a product liability class action gets off the ground, and then how the defence gets off the ground.
I mean, I think it depends a lot on what the particular matter is. So one of the reasons that it was timely for me to be talking about product liability class actions is I was in the process of settling one that came off the back of a worldwide recall. So obviously we see a lot of those in Australia that would often be referred to, say, copycat type actions. It's strictly not true because obviously the dynamics in Australia are different because of our consumer law compared to elsewhere, but they do tend to come off the back of things that have happened overseas. As a result, I think plaintiff firms initially thought that they would be quite easy to run because, you know, it's run elsewhere. Why wouldn't it work in Australia? But it's not always the case. So we are sort of, I think, seeing them be a little bit more strategic about the ones that they bring and the ones that they don't for that reason. In this particular case, the defendant, one of the defendants actually ended up filing for Chapter 11. So that made it quite a different outcome for the plaintiffs than it would have in others. But yeah, it's sort of, we as I said, we do sort of see that copycat kind of approach. Funding hasn't changed too much. I mean, we do have a lot of litigation funding here in Australia. We have had for a long time. The one change that we have seen is in one of our jurisdictions in Victoria, there's now what the US would refer to as a contingency model process for law firms. So they can fund themselves and take a cut, whereas no other jurisdiction in Australia you can do that. And that was only introduced coming up to 6 years ago now in Victoria. So that was a pretty big change, allowed firms to do things without funders behind them if they wanted to, which I think has led other players to come into the space that potentially weren't there before.
Sure. Sticking with funding for a minute, I'm interested in the kind of overall funding vibe in Australia. Here in England and Wales, it's pretty much settled. As you know, we've had a couple of bumps in the road with a PACAR Supreme Court ruling, but legislation is overriding that, and it really hasn't caused too much of a stir in the end. The ancient principles of champity and maintenance seem to have gone out the window, but are remaining in Ireland.
To keep you all on your toes.
Absolutely, and our friends and neighbours in the EU, despite the despite various directives, are moving a sort of a multi-speed track to get opt-out class actions on track with a kind of definite policy regarding funding. Is funding equally controversial in Australia, or is it settled?
Pretty settled. It's not. There was a big issue back in the day about whether funders. Well, actually, it was an issue in a case I was involved in many years ago, whether they needed to be licensed with our financial regulator because of what they were doing. The decision was yes, they should, given what they're doing, but they've been given an exemption to that. That's been given on a rolling basis for years now. I imagine at some point it will be legislated, but it hasn't been. So they can operate quite easily in Australia, and they do. It's been, I think, quite a fertile market for funders as a result. So yeah, it's pretty settled. As I said, the difference was the ability for law firms to fund that came in recently, but in terms of funders themselves, it's pretty settled.
Yeah, and sort of linked to the same question, there's been a couple of instances over here where proceedings have gone on for years, or at least the preparation for proceedings, and you win or you get a settlement, and after all this expense, all these millions of pounds, you get 25 quid back on your train fare or something. And there is a school of thought over here that there might be a better way of achieving satisfaction for relatively small sums for consumers than going through this quite convoluted legal process where a lot of law firms and a lot of funders make a lot of money for relatively small individual payouts. So I wonder if that conversation is happening in Australia at all.
Constant conversation for sure. I don't think we have the answer to it yet either. I mean, it's obviously that's the difficulty with this market is these are claims that would never be brought by the individuals, and rightly so. So, if they get something back, that's, arguably better than nothing. But yes, it does. There was a big story on one of our programs here about that exact issue recently. So no, we haven't got the answer yet either. Don't worry, it's still a live issue here.
Excellent. We're just going to all have to work it out for ourselves, aren't we? Now, I noticed looking down your noble and impressive case history that you've acted in a lot of matters that kind of dovetail between what I think in Australia actually are very active regulators and private litigants. And how closely are regulators involved these days in class actions, and how should defendants, your clients chiefly, manage that overlap?
Yeah, a lot of class actions have a precursor to them, which is regulatory action. I mean, the market here, they've sort of just finished, but we had a Royal Commission in relation to the financial services industry back in 2018, and there were, I couldn't even count how many class actions came out of that conduct, that Royal Commission, because there was so much that came out of it that wasn't known or perhaps hadn't received the sort of the press that it had or did during the Royal Commission. So regulatory activity, absolutely, both in the financial and the consumer space. So you will see activity by a consumer regulator like our competition regulator that was a precursor to class actions. I mean, how can our clients avoid it? Obviously, try and stay out of the regulator's glare. But that's not always possible. I think remediation activities with the regulator really help. So to the extent that you've already remediated a number of these people, the class actions don't have the same sort of commercial viability that they otherwise would. So that's a good one to think about if you do find yourself in a regulator investigation, thinking about how you can potentially get ahead of remediating customers is a good way to try and avoid the class action coming along. It may not avoid it entirely, but it does make loss difficult for the plaintiffs if most of them have been remediated. The other thing there, I think, and this comes up a lot when talking to people overseas, is our regime is opt-out. So to the extent that you've already been remunerated, you wouldn't be necessarily able to to get a recovery in the class action, and maybe inclined to not even try because you're already happy and you've opted out, you'll opt out as a result. So I think there's sort of ways to try and get ahead of it, but unfortunately it's par for the course, I think, with regulators. That, you know, they will do what they need to do, and it's important work, and there's likely to be things that come off the back of it.
This has been a joy, Amanda. Thank you so much.